Thank you, everybody, for joining our webinar this morning. We're going to look at fair housing and how it applies to cities, villages, and townships in terms of zoning and land use. I'm going to ask you a couple questions. What ways do fair housing laws apply to zoning and land use laws and ordinance, or the application of the land use in zoning ordinances? And what are main legal theories that have been used to challenge zoning and land use decisions and policies and practices? And what types of land use, zoning, and practices have been found to run afoul of the fair housing laws? And what are some of the factors that the Supreme Court identified in Village of Arlington Heights case to determine whether municipality has an invidious, unlawful, or discriminatory motive as to its land use and zoning practices? Are there any fair housing issues involved that can arise in code enforcement? Should a municipality use a crime-free lease addendum? We have a municipality that requires landlords, specifies where landlords have to do criminal record checks of tenants. And what is the Religious Land Use and Institutionalized Persons Act? How does that apply? Just to make sure people are on good grounds when it comes to land use and zoning decisions. The webinar is being recorded. It's intended, again, to provide general advice, not legal advice on a specific situation. Feel free to contact our office. Contact information is there if you need additional assistance. The questions go into the Q&A, not the chat. I think the chat's disabled, so you don't have a choice there, I guess. You can put on closed caption if needed. The webinar and PowerPoint will be posted on our website and on YouTube, so you'll be able to pick that up if you want to look at it later. And videos of other webinars and conferences are also available. Thank you, Mishta, again, sponsoring the webinars. We really appreciate their support. They've been outstanding, a pleasure to work with. Hopefully it's something that we can continue to do. I've done, I think, 11 or so this year, quite a few last year, and it's just been a great experience. So questions, can use the Q&A. I think the chat's disabled. Anyways, so just to kind of to get started, and I'm going to put my camera off because otherwise when I see the video replayed, I got my face all in the corner all the time. Maybe some people like the way they look at, that's not my favorite thing. But I'm here, even if you don't see me on the video. So land use and zoning, is that kind of boring? Or is it controversial? What do we know about it? And I have a good little illustration to kind of kick us off. Any basketball fans out there? Anybody who's watched basketball knows that Steph Curry can make 3 points from a long way away. Looks like there's no distance too far for Steph Curry. But anyways, as to zoning and land use, Steph and Ayesha Curry oppose upzoning of their Atherton property, of an Atherton property near their home. And they actually sent a letter in opposing 23 Oakwood development near their home. So what happened is there's the town wanted to upzone a 1.5 acre lot where there's currently a single family home. The property owner plans to develop up to 16 townhouses. And the Curry sent a letter opposing the project, saying they had major concerns in terms of both privacy and safety with the three-story townhomes looming directly behind us. They asked the town at a minimum to build taller fencing and landscaping to protect views into their property. As Atherton residents, we have been following along with the housing element updates with special interest in the 23 Oakwood property, they wrote in a January 18th letter to the town. We hesitate to add to the quote unquote, not in our backyard, close quote, literary rhetoric, but we want to send a note before today's meeting. Safety and privacy for us and our kids continues to be our top priority. One of the biggest reasons we chose Atherton as home. The family isn't alone in opposing the project. Other neighbors expressed concern about developing multi-family housing on the site in letters and public comment during town meetings, right? Initially, the town's growth plan had been to lean on backyard accessory dwelling units, but town consultants and housing advocates made it clear the state won't accept an element that doesn't include some kind of multifamily housing. The couple noted that the town already recognized that 23 Oakwood townhouses would not contribute to the very low or low income housing quotas required by the state, and they're pleased when it's previously moved from the housing element. And the council member, one council member said it's not possible to build low-income housing in Atherton since land is worth about $8 million per acre. We kindly ask the town adopts a new housing element without the inclusion of 23 Oakwood, the Currys wrote. Should that be not sufficient for the state, we ask the town commits to investing in considerably taller fencing and landscaping to box sight lines onto our family's property. So the plan was due to go before the State Housing Community Development Department on Tuesday, January 31st. And we're going to take a look at this at the end of this webinar to see what the status of it is. So what do you think? Curry's wrong? Or, you know, I think it's controversial. Certainly it can be controversial. But let's see what the standards are, what the guidelines are when it comes to zoning and land use. So in the first part, we're going to look at major fair housing laws as zoning and land use, HUD DOJ guidance and theories of liability. The second part, we're going to look at specific kinds of land use and zoning practices that violate the fair housing laws. You see them listed there. And the third part, we're going to look at the Religious Land Use and Institutionalized Persons Act and how that applies to zoning and land use policies and practices by municipalities. So what are the major fair housing laws as to zoning and land use? Of course, there's the Fair Housing Act. The protected class categories are on the right. Then we have the Civil Rights Acts of 1866 and 70. We refer to it as sections 1981, 1982. That's the bedrock fair housing laws. Covers race, color, ancestry, and alienated status. There's Title VI that applies, and that applies to requires financial assistance, covers race, color, national origin. The Americans with Disabilities Act applies, and the Rehabilitation Act, both of those protect discrimination against persons with a disability. And our state law in Michigan, Michigan Elliott Larson Civil Rights Act and Michigan Person with Disabilities Civil Rights Act. So it's you can see it's quite a few list of laws, right? If I go back for just a second, Religious Land Use and Institutionalized Persons Act also applies as well, but we'll cover that separately. So just looking to the Fair Housing Act, I mean, does it talk specifically about municipalities? Actually, it's only mentioned once in the text of the Fair Housing Act. When I say FHAA, I'm referring to the Fair Housing Amendments Act of 1988. The Fair Housing Act was passed originally in 1968, and the amendments in 1988 added familial status and disability. So if you're referring to FHAA, Fair Housing Amendments Act, it's referring to the current version of the Fair Housing Act with the 88 amendments. But it's only mentioned once. What it basically said is in the Fair Housing Act is that if HUD receives a complaint involving a local zoning or land use law or ordinance or the application of it, it could be a neutral, it could be a non-discriminatory one, but it's applied in a discriminatory fashion, that would also be a violation. HUD investigates, and if they find that there's no cause, HUD will dismiss the complaint. However, if HUD determines that it is cause, HUD believes that there has been a violation, HUD will refer those complaints to the Department of Justice. So that's a little bit different than what you may expect. So you're not going to see HUD doing major work in this area. And that because of that, enforcement largely resting with the Department of Justice, HUD is kind of taking hands off to some extent when it comes to local zoning and land use. Not that it doesn't have involvement, but not in the same level that it would with other areas of the law, again, because the Department of Justice has to step in. HUD's implementing regulations carries forward that same idea. And instead of making a determination of cause as to a violation of the Fair Housing Act, HUD will refer it to the Attorney General. And then the only other part that's mentioning municipalities in the Fair Housing Act deals with the design and construction requirements of the Fair Housing Act. Covered multifamily dwelling units are buildings with 4 or more units connected. If all units, if the building has an elevator or elevators, it's only the ground floor units if there's no elevator. So those are subject to design and construction requirements. There's 7 of them. We've got a separate webinar on our website that deals with these 7 a good overview of the 7 design and construction requirements. Those only cover new constructions, not existing constructions. So where it mentions in terms of design and construction requirement is that if the state statutes or local ordinance incorporate the Fair Housing Amendments Act's design and construction requirements, compliance with the statutes or ordinance shall satisfy the requirements under the Fair Housing Amendments Act. That's one provision. I don't know of too many local state statutes or local ordinances that have gone into that kind of detail incorporating the Fair Housing Act design and construction requirements. A bigger thing is this: it says state and local governments may but are not required to review and approve new multifamily dwellings to determine whether they satisfy the Fair Housing Act's design and construction requirements. And that's where it becomes kind of a trap per se, I suppose, because sometimes architects, builders, developers think that because they receive local approval for their building plan, that they're in compliance with all laws. No, it's not. And you can see the next section, state or local determinations as to whether new construction satisfies design and construction requirements under the Fair Housing Act are not conclusive in enforcement proceedings under the Fair Housing Act. So you can't, like, courts are not going to rubber stamp what's been done at the local level. The Congress didn't want to put that obligation onto local municipalities in terms of determining design and construction requirements. Again, however, in the final section 2, nothing is construed in the should be construed in the Fair Housing Act to invalidate or limit any state or local law or ordinance when it comes to design and construction requirements that grant people with disabilities even greater rights. So they can do increase, like, for example, there could be a building without a covered multifamily dwelling without an elevator, and the municipality can require some of those units as well on the upper floors without an elevator to be built in accordance with design and construction requirements, giving additional protections for people with disabilities. But again, it's not something that's required, but they're permitted to do so. So getting more to land use, the main legislative history for the 1988 amendments is the House report. And it's really almost like the sole really strong legislative history for it. But you can see, right, these new subsections in 1988 amendments to the Fair Housing Act would apply to state or local land use and health and safety laws, regulations, practices, or decisions which discriminate against individuals with handicaps, right? While state and local governments can protect health, safety, regulate the use of land for those purposes, it's often been used to restrict the ability of individuals with handicaps to live in the communities. There can be an imposition of health, safety, or land use requirements on congregate living arrangements among non-related persons with disabilities and so forth. So you can see the committee intends that the prohibition against discrimination against those with handicaps apply to zoning decisions and practices. So it's a clear intent for Congress to have the 88 amendments applied to land use and zoning actions by municipalities. So how does the Fair Housing Act apply to state, local land use and zoning? The HUD and Department of Justice, they have concurrent enforcement under the Fair Housing Act, right? They agree. Well, again, HUD is terms of investigation and DOJ primarily will do the enforcement, but they make clear that the Fair Housing Act prohibits state and local land use and zoning laws, policies, and practices that discriminate based on a characteristic protected under the act. You can see it's a little bit broader. They're not just taught in the HUD DOJ policy guidance, doesn't just talk about when it comes to disabilities, but it actually covers all protected class categories under the Fair Housing Act. So I would say too, the housing includes under the Fair Housing Act, not only buildings intended for occupancy as residents, but also vacant land that may be developed into residences. So it's not that the Fair Housing Act kicks in once there's a dwelling there. No, it can be a vacant land that's planning to be purchased and used for a particular purpose. And then at that point, if it's residential related, some kind of residential related plan or purpose for use, that vacant property, then the Fair Housing Act would be applied to that. So what are the legal theories? Two main ones, disparate treatment and disparate impact. We'll talk about reasonable accommodation a little bit later. Most commonly is disparate treatment, requires proof, either direct or indirect, of discriminatory intent against one or more members of a protected class. It can be inferred sometimes by showing similarly situated persons, protected class person and not protected class persons are treated differently. Disparate impact is less often alleged, but it's a facially neutral policy or practice. It has adverse, disproportionate, adverse impact on members of a protected class. I should add on here too, under the Fair Housing Act, there's different than employment because it also involves perpetuation of discrimination will also give rise to a disparate impact claim, typically shown through the adverse effect or impact shown through statistics, but there is no requirement to show discriminatory intent. Intent is not a factor on a disparate impact case, though often it's underlying it. Maybe just the proof isn't there. No one was there in the meetings when those kinds of, intent statements as to intent were made, but it's not required as a proof element in disparate impact claims. We're going to see a couple examples of these in a little bit. So disparate treatment, the key one when it comes to zoning and land use, the key factors are found in the Village of Arlington Heights case by the U.S. Supreme Court in 1977. That is still followed. It's still the good law. It's a controlling standard when it comes to disparate treatment cases. And the Supreme Court said determining whether invidious discriminatory purpose was a motivating factor demands sensitive inquiry into such circumstantial and direct evidence of intent as may be available. So it is quite a detailed factual analysis. Supreme Court said you look at the impact of the official action, whether it bears more heavily on one race than another is kind of a good starting point, or it could be a clear pattern, unexplainable on grounds other than race emerges from the effect of the state action, even when the governing legislation appears neutral on its face. And then absent kind of direct evidence, right? Then you start to look at other factors including historical background of the zoning and land use decision, particularly if it reveals official actions taken for invidious purposes, specific sequence of events leading up to the challenge decision. For example, if property had always been zoned R5, but suddenly was changed to R3 when the town learned developers plan to erect integrated housing. And there are cases that still involve that, where just a sudden change occurs once a group wants to use property for a particular purpose, typically low-income housing, then suddenly the zoning changes, right? There can be also departures from normal procedural sequence that might afford evidence of improper purpose. Substantial departures may too be relevant, particularly if the factors usually considered important by a decision maker strongly favor a decision contrary to the one reached. For example, there could be studies showing what the effect on schools, traffic, so forth, and it shows that the development is fine, right? And then it goes before a hearing, public hearing, suddenly the zoning classification is changed, but there's been no study as to why, right? What is the effect on traffic and all those things? Or it was showed that it would be fine having a new development, but suddenly zoning gets changed. There's no study, and all of a sudden the new zoning ordinance or the amendment to the zoning ordinance goes through, or property is, reclassified. Legislative administrative history may be highly relevant, especially when they're contemporary statements by members of the decision-making body, minutes of his meetings or reports, or could be members of the public as well. And these are not exhaustive, right? These are just illustrative. The Supreme Court is being illustrative factors that you look to see whether there's discriminatory treatment or disparate treatment. Disparate impact is quite a bit different. There is a prima facie element. Plaintiff has the burden of showing that a facially neutral policy or practice has an actual or predictable result on a disparate impact against a group of persons, generally, or creates, increases, reinforces, or perpetuates segregated housing patterns. Often these are typically statistical proof to show this. Once that occurs, the defendant has the burden to show legally sufficient justification for the facially neutral policy or practice. In other words, show that necessary to achieve one or more substantial, legitimate, non-discriminatory interests of the land use or zoning ordinance or application of it. And it must be supported, the sufficient justification must be supported by evidence and may not be hypothetical or speculative. Then the burden then shifts back to the plaintiff to show another practice, alternative practice, that can achieve the legitimate interests served by the policy with a less discriminatory effect. So those are the main theories. It's probably better to look at in terms of actual applications in cases. So part two, we're going to look at land use and zoning practices that violate the fair housing laws. There's 5 listed here. Some a little bit like 2 and 3 kind of overlap a little bit, but I've taken this from a policy statement that HUD put out, and that's how they divided it up. So what are they violate the fair housing law? There can be prohibition or restrictions on new housing developments. There can be prohibition or additional requirements on group homes. Group homes many of the cases involve group homes. And I should say this, there's just tons of fair housing cases when it comes to zoning and land use. It's one of the major areas in fair housing law. There can be imposition restrictions or imposing restrictions or special requirements. Hot topic recently has been code enforcement. And then there's a major issue as to denial of accommodations. Accommodations actually kind of overlap some of the other ones, but we'll get to that in a second. So what are the common challenges? There's 2 main scholars I could put. Professor Schwem has a treatise on housing discrimination law and litigation, and from attorney practitioner standpoint, John Rowman, Housing Discrimination Practice Manual, and they both have give common categories or challenges of land use regulations on group homes. First one is single family zoning that prevents a group home from locating in an area where only traditional families and small groups of unrelated persons are permitted. You see those where they'll say, a family unit, whatever, is limited to 6 people or 4 people or 5 people, 10 people who are unrelated. There's also other zoning rules and classification that block or restrict a group home from operating in a dwelling. There's issues as to spacing requirements that forbid operation of a group home closer than a certain minimum distance from other such facility, or dispersal requirements on group homes for the disabled. There can also be special use and health and safety rules that apply to group homes, or that operate to discriminate against persons with disabilities. We'll see an example of that. There's also neighbor on neighbor provisions and notification requirements that apply only to group homes. As also, there have been a number of cases of state court enforcement of private restrictive covenants that are restrictions on group homes. So the first one is prohibitions or restrictions on new developments. Again, HUD and Department of Justice have a joint statement on state and local land use laws. And they said prohibiting or restricting development of housing based on the belief that residents will be members of a particular protected class, such as race, disability, or familial status, for example, by placing a moratorium on the development of multifamily housing because concerned that the residents will include members of a particular class. So Congress in the 88 amendments in the House report made a favorable reference to the Supreme Court's decision in the city of Claiborne case. And it really predated the 88 amendments to the Fair Housing Act, but it's very, very important in terms of constructing the Fair Housing Act before and after its amendment. It was approved by the House in the House report. Basically, the Supreme Court in Claiborne said, this is what the House report says, the Supreme Court held there's no rational basis to exclude citizens with mental retardation from living in the community. In that case, the city zoning board ruled that residents with mental retardation posed a variety of dangers which precluded them from safely living in a home in the community. The court examined each danger and concluded each was based on a stereotype, not an actual fact. So what happened is the zoning ordinance required a special use permit for homes for the mentally disabled. The city didn't require a special use permit in R3 zone for apartment houses, multiple dwellings, boarding and lodging houses, etc. But it did insist that the special use permit, right, for a particular Featherstone home because it would be a facility for the mentally retarded. And the question is, can the city require a permit for this facility when other care and multi-dwelling facilities are freely permitted? And there was nothing in the record below that shows the mental Featherstone home. In other words, persons that are mentally disabled living there would pose any special threat to the city's legitimate interests. And that right there tells you that the special use permit requirement would be invalidated. So why did the city adopt it? City council was concerned with the negative attitude of the majority of property owners located with 200 feet of the facility, as well as fears of elderly residents in the neighborhoods, right? They cannot, right? That's insufficient, has to be based on something factual, right? Private biases may be outside the reach of the law, but the law cannot directly or indirectly give them effect. So what were the negative attitudes, right? They just didn't want that home near where they lived, right? It can't, city, again, people can have biases, they can make all kinds of statements, but a city council cannot act based on that. Then the location, the council had two objections: location. It was concerned that the facility is located across the street from a junior high school, and some of the students might harass the occupants of the Featherstone home. They said the Supreme Court said that's not really had a good foundation because the school itself had 30 mentally retarded students. I'm quoting the court decision. And denying a special permit based on such vague, undifferentiated fears is again permitting some portion of the community to validate what would otherwise be an equal protection violation. Another objection was that the home was located on a 500-year floodplain. But again, that's wouldn't simply, that if that applied to the Featherstone home, it would apply to all other kinds of homes where people were able to get permits without obtaining or be able to occupy and use those properties without a special use permit. Right. So you can see, right, location of the facility was not sufficient to require a special use permit. The size of the home and the number of persons who would occupy the home, right? If, in other words, evidence was clear here that if the potential residents of the Featherstone street home were not mentally retarded, but the home was the same in all other respects, its use would be permitted under the city's zoning ordinance. So there are no restrictions on the number of people occupying the home as a boarding house, nursing home, family dwelling, fraternity house, or dormitory. So why would the home housing people with mental disabilities be treated differently, right? There wasn't any real clear connection as to what it is about the residents of the Featherstone home which warranted them being treated differently, right? I get the bottom line is, in the words of the Court of Appeals, the city never justifies its apparent view that other people can live under such crowded conditions when mentally retarded persons cannot. Again, it comes up all the time, avoiding concentration of the population and lessening. I got a couple of questions here. Let me ask you this. Does the Fair Housing Amendments Act only apply to developments getting subsidies for HUD or state and local governments? No, applies across the board. Doesn't matter. Good question, right? If you're talking about, well, first off, if you're talking about local governments, they all, virtually all receive some type of federal financial assistance or involved in programs involving federal financial assistance. So all of these laws are going to apply. But you don't have to show that under the Fair Housing Act. There's no requirement that there be federal financing involved. If there is federal financing involved, then the other laws kick in, meaning Title VI, Section 504, ADA, and so forth. So concentration of the population, lessening congestion of the streets. These concerns fail to explain why apartment houses, fraternity and sorority houses, hospitals, and the like may freely locate in the area without a permit. Certainly, those other types of facilities will cause concentration of the population and congestion in the streets no differently. So too, the express worry about fire hazards, friendly to the neighborhood, avoidance of danger, all of those things apply to any type of housing, right? But why it just looks like what the home on Atherton is being singled out for a special use permit, yet no other such restrictions on the many other uses freely permitted in the neighborhood. And in conclusion, it's quoted a lot by later decisions. The short of it is that requiring the permit in this case appears to us to rest on an irrational prejudice against the mentally retarded, including those who would occupy the Featherston facility and who would live under the closely supervised and highly regulated conditions expressly provided for by state and federal law. So that's a real important decision. Just a couple one here is a real great illustrations on prohibition or restrictions on new developments. This is a case study, Haney Management Inc. versus County of Nassau. Facts here are pretty compelling. Garden City is located in Nassau County. It's really, this case is really a roadmap as to what violation can look like. So during the time period, Hispanic African-American families comprise about 20% of Nassau County's population. These minority groups comprise a disproportionate share of the county's low-income population, while 14.8% of households in Nassau County, African-American Hispanics, represented 53% of the county's very low-income, non-elderly renter households. In addition, African-Americans made up 88% of the county's waiting list for Section 8 housing. That's at the county level. At the state level, Garden City. Yeah, by the way, just I am noting above, it looks like a little bit of conflict, right? Because, I see, it's 20% of the population as a whole, but 14% of those households would be considered within the county would be considered very low income. And they made up 53% of the county's very low income. Within Garden City, quite a bit different. Why? Because there's just so very, very few. The percentage of African-American Hispanic population is just 4.1%. But once you exclude 61% of the minority populations are students living in dormitories. Once that group is excluded, Garden City's minority population, only 2.6%, and only 2.3% of the households were headed by African-American or Hispanic persons. Several of the communities surrounding Garden City were majority minority, in which minorities make up a majority of the population. So you can see this is a segregated community. Although a lack of affordable housing has been a problem in Nassau County, Garden City, in Nassau for Nassau County, it's a problem in lack of affordable housing. Garden City contains no affordable housing. In fact, in the past, Garden City's residents have resisted the introduction of affordable housing into the community. The court decision, it goes through in detail, attempted introduction of affordable housing and how that ended up getting blocked every single time. So they've never had any affordable housing in Garden City. So here's the plaintiffs. Nassau County had a formal social service building with parking lots and ancillary facilities and that. So Nassau County wanted to sell it. They wanted to sell it for $30 million. And the plaintiff developers wanted to purchase the 25-acre site from the county. And Nassau County indicated to Garden that Nassau County communicated with Garden City that the property needed to be rezoned, the site needed to be rezoned. Now, a subcommittee of the Garden City's Board of Trustees considered proposed rezoning for more than a year, proposed applying multifamily residential group or RM zoning controls to the property. RM zoning would allow up to construction of 311 residential apartments on the site or 75 single-family homes. And again, the plaintiff developers wanted to do the 311 residential apartment units. That was their plan. Several hearings were held. The board, without any draft EAF being issued, abruptly rezoned the site to residential townhouse or RT. an entirely new zoning classification. This classification ensured that developers could not create affordable multifamily housing on the site. So in the process of that, suddenly it got rezoned to residential townhouse. The following month, Nassau County issued an RFP saying the county would require bids of not less than $330 million. The plaintiff developers were unable to submit a bid conforming to the specifications of the RFP because RT zoning classification made the building of affordable housing financially unfeasible. When I say RT, residential townhouse, it's not feasible. County then awarded a contract to a developer of single-family homes for $56.5 million. That was the highest built. A developer was going to propose construction of 87 single-family detached homes with no townhouses. Here's the thing, under the RM zoning classification was rejected, the pool of renters likely to occupy all the units, including market rate and Section 8, would have been between 18 and 32% minority, totaling between 56 families to 101 families. On the flip side, because with the 87 single-family detached homes, estimate was only 3 to 6 minority households could afford to purchase single-family units. So the plant developers brought disparate treatment and disparate, impact claims. The Second Circuit upheld the finding of disparate treatment, knowing that the sudden abrupt change was a capitulation to the citizen fears of affordable housing, which reflected race-based animus. There was a tenor discussion in public hearings, a flyer circulated, showing that citizen opposition, though not entirely overtly race-based, was directed. Again, no one came forward and said, well, we don't want Black people living here. We don't want Hispanic people living here. But it was directed in a way of poor potential flux of poor minority residents. Garden City residents expressed concern that RM zoning would change the flavor and character of Garden City. In Garden City they made the argument in the case, because no one ever said anything overtly race-based, this was all just business as usual. But the district court, using the Arlington Heights factor, says something was amiss here, and Garden City's abrupt shift in zoning in the face of vocal opposition to changing the character and nature of Garden City represented acquiescence to race-based animus, right? It said, the Second Circuit agreed with the district court, given the racial makeup of Garden City and likely number of racial minorities who would be moving into the planned development, residents believed would have lived in affordable housing at such service site. These comments were code words for racial animus. And here they cited a series of studies showing that when whites were asked why they would not want to live near African Americans, again, without any income level being indicated in the question, common responses relate to fear of property value decline, increasing crime, decreasing community quality, and increasing violence. Repeatedly expressing concern that RM zoning would lead to a decline in their property values and reduced quality of life. They urged the board trustees to keep Garden City what it is and to think of the people who live there. Considering these comments in context, we find a district court conclusion that citizen opposition to the zoning utilized code words to communicate their race-based animus to Garden City officials was not clearly erroneous. By the way, studies where there has been low-income development in communities does not really result in a big drop of property values. It shouldn't. So I wish I could go into more detail. I'd be reading the whole case, but it's just fascinating, the things that were said. The evidence is so compelling. I look at that, I almost wonder why the plaintiffs brought a disparate impact claim, because the disparate treatment claim was so strong. But as to disparate impact claim, again, there's two ways of doing it. One is disparate impact on a statistical evidence or prima facie case of disparate impact on a protected group. And the other one is perpetuation of segregation. This practice here, the policy here, clearly had a perpetuation of segregation. So there's always the 3 steps to a disparate impact claim. The first one, statistical proof of perpetuation of discrimination. Again, as noted above, minorities are just 4.1% of the city's overall population. And once you exclude out students, college students, and only 2.6 of the population living in households, the city contained no affordable housing. The original multifamily residential group, or RM zoning, would have allowed plaintiff to construct up to 311 residential apartment sites. And the city zoning policy restriction, I should say, suddenly new zoning policy to kind of wipe out the possibility of residential apartment units, certainly perpetuates segregation within the city. Legitimate interest, the city made the argument that rezoning advanced legitimate interest by reducing traffic and strain on public schools. There was a previous study which showed that the development would not have done that, actually. But the court appeals on this point accepted it. On step 3, HUD's disparate impact regulation requires the burden of proof on the third element to be on the plaintiff. Previously in the Second Circuit, the step 3, the obligation was on the defendant to satisfy that, because the city put the burden on the city rather than on the plaintiff to establish the absence of less discriminatory alternatives. The court reversed, remanded the case to the district court to address the third step. So again, this shows not only disparate treatment, but also evidence that there's a perpetuation of discrimination. So those are two pretty compelling cases, right? As to, right? Come back to it here, right? On prohibitions or restrictions on new development. Both, right, came flat out because of the policies that were done in terms of zoning and land use. Those new developments could not go forward, and both of those were struck down by the courts. Second one is prohibitions or additional conditions on group homes. And there's a number of cases that have involved this. And just again, showing analysis between the requirements or conditions on group homes as opposed to other groups of unrelated individuals or other requirements for group homes. There's a number of them. There's a couple illustrative cases. Larkin is one. It's a Michigan case. Plaintiff wanted to do an adult foster care facility, provide care up to 4 disabled adults in Westland, Michigan. They're subject to the Adult Foster Care Licensing Act. Michigan's Adult Foster Care Licensing Act prevents the issuance of a temporary license if the proposed AFC adult foster care facility would substantially contribute to an excess concentration of community residential facilities within a municipality. That is an issue, right? Because it looks like it's targeting adult foster care facilities by not wanting an quote excessive concentration of them in a community. So the Michigan Adult Foster Care Licensing Act required compliance with the state's Zoning Enabling Act, and the Zoning Enabling Act in Michigan stated a state licensing agency shall not license a proposed residential facility if another state licensed residential facility exists within a 1,500-foot radius of the proposed location, unless permitted by local zoning ordinance, or if the issuance of the license would substantially contribute to an excessive concentration of state licensed residential facilities within the city or village. So the Michigan Department of Social Services notified Westland of Larkin's application, and Westland determined there was existing adult foster care facility within 1,500 feet of the proposed facility. And it also notified the state, Westland notified the state it was not going to waive the spacing requirement so that that the state could not issue a license to Larkin. Right. Once the state informed Larkin of Westland's action, Larkin withdrew her application. The Sixth Circuit said the challenge portions of the Michigan Adult Foster Care Licensing Act are facially discriminatory. The space requirements prohibits MDSS from licensing any new facility if it's in 1,500 feet of an existing AFC facility. That is a facially discriminatory because that's not imposed on other facilities, just on adult foster care facilities. It says here the notice requirements require MDSS to notify the municipality of the proposed facility and the local authorities to then notify all residents within 1,500 feet of the proposed facilities. These terms only apply to adult foster care facilities which will house the disabled and not to other living arrangements. That is singling out regulated group homes for handicap are facially discriminatory. And I say handicap, I'm quoting from the court. The Fair Housing Act uses, in 88 Amendment, uses handicap. The more common, accepted term is disability. And there's several citations here. Because it's singling out adult foster care facilities for special treatment. Adult foster care facilities are house people are protected under the disability provisions of the Fair Housing Act. So that's going to be facially discriminatory. You can see some of the sites here. 1,000-foot spacing requirement is facially discriminatory. So this is a case of intentional discrimination or disparate treatment rather than disparate impact. All right, so there is facially discriminatory. So they're saying, the state says, well, statutes and issues can't have discriminatory intent because they're not motivated. They're not motivated by malevolent or improper motives, right? They're trying to make it seem like we're protective of people who are in adult foster care homes, right? The Supreme Court Johnson Controls decision, all the courts which have considered the issue under the Fair Housing Amendments Act have concluded that the defendant's benign motive does not prevent the statute from being discriminatory on its face. You don't get into intent like that. There's numerous cases. For example, we had one where someone had a mobility impairment and she wanted to reside with her friend on the second floor unit. There were steps going to the second floor. And it said because of her impairment, she could fall and get hurt. So to protect her, we're not going to allow her to live on the second floor. We don't want her to get hurt, right? But that's still, it's not benign. It's not innocent in terms of fair housing because you're still discriminating against someone because they have a disability, and it's making housing unavailable to someone because of their disability. So who makes the decision? She does, where she lives, right? So, but claiming benign, paternalistic, things like that, does not prevent. In fact, that gets flipped around. That really is just more evidence of discrimination. Another way that there's violations imposing restrictions on housing because of alleged public safety concerns that are based on stereotypes about the residents or anticipated residents' membership in a protected class, requiring a proposed development to have additional security measures based on a belief that persons of a particular protected class are more likely to engage in criminal activity. And again, these can be facially discriminatory. Here's a Mubarak case. Plaintiff was awarded a grant to establish a family consortium home, and under state agency rules, it's a Ohio case, family consortium consists of individuals with mental retardation and developmental disabilities and a group of their relatives who wish to provide for these individuals a home which is an extension of their family home. So you kind of see it's a kind of between the family and the organization kind of work together, invested together, bought the home to make it more like a family type arrangements for people with disabilities, developmental disabilities. So plaintiff and certain parents purchased single family residence. The home was located in an area zoned single family dwellings. The parents were told they needed a conditional use to permit to use the home as a boarding house rather than a single family dwelling. The city law director said, hey, they need to satisfy the city zoning code, which required extensive safety protections for homes, housing individuals with developmental disabilities. That's a problem, isn't it? Why? What is it about people, homes, housing individuals, developmental disabilities? Why are not those same safety concerns for other types of homes, housing individuals without developmental disabilities? So it's facially discriminatory. It said it's facially discriminatory, according to the district court, because it imposes safety requirements which are more stringent than safety requirements applied to other single family residents. And the ordinance makes no effort to tailor the safety requirements to particular disabilities of the plaintiff's residents. In other words, what are the specific factors of developmental disability, persons with developmental disabilities that need that kind of safety and precautionary measures in place, right? The city would require that Mubarak install an alarm system interconnected to a ceiling sprinkler system. It offers no evidence that any of the residents of the home are hearing impaired or otherwise unable to respond to standard smoke alarms, which the home is already equipped. They wanted them to install push bars that swing outward with lighted exit signs posted above each door without offering any evidence that residents are would be unable to use the type of doors already in the home. And so forth. You can see all the requirements. The city's blanket fire and safety restrictions apply to all homes where developmentally disabled persons live, regardless of the individual abilities of the residents, are based on false and overprotective assumptions about the needs of handicapped people, as well as unfounded fears about the problems that their tenancies may pose. Right? And as a result, it limits the opportunity of residents to live in the community of their choice or right guaranteed them by the Fair Housing Act. You see the idea, and then underlying this too is the part with the, we're going to see in a minute, a reasonable accommodations where someone can ask, or an applicant can ask for a relaxation of these requirements, basically showing that they're not needed in terms of the particular housing or group home at issue. But here there was no choice. But the city inquired it, and that was it. Right? The city, so again, the net effect of it be what? Denial of housing. Code enforcement, this has been a real hot topic. There's a new DOJ joint statement dealing with this. It's in the joint statement of local land use law. They mentioned it with terms of code enforcement, forcing otherwise neutral laws or policies differently because of the residents' protected class characteristics. For example, citing individuals or members of protected class group for violating code requirements or property upkeep while not citing other residents for similar violations. This has really spread around the country. And there's nuisance ordinances that penalize housing providers, landlords for excessive number of calls for police service from a property or about property. Ordinance using a point system. And then if property accumulates a certain number of points within a 12-month period, the property is considered a public nuisance. So you can see what happens. Penalizes property owners when two or more perceived violations of any laws occur near the property involved in tenant property within a 1-year period. Those are nuisance ordinances. There's crime-free housing ordinances requiring landlords to get a rental license and threaten the loss of the license if the landlord does not conduct background checks on all tenants. I've seen those. They even specify what kind of criminal record check needs to be conducted. And then it also requires landlords to evict any tenant that's alleged to engage in criminal activity on or near the premises. And some even go so far as to require a lease addendum that prohibits resident household member guests from engaging in acts of violence or threats of violence, such as unlawful discharge or firearm on the premises. So what happens, where did all of this start? Well, it started in 1992. It was, what's the name of it's an Arizona city, but a member of the Arizona Police Department, he founded International Crime-Free Association. And what they did, ICFA developed a crime-free lease addendum and other templates or guides, which have then spread and been adopted by other local jurisdictions. It's so widespread, an estimated 2,000 municipalities across 48 states have adopted crime-free housing ordinances. And so what are the common attributes? Again, it requires landlords to be licensed to rent properties. And they have to, sometimes landlords even required to complete crime-free housing training. The tenants and adult household members must sign a crime-free lease addendum. And if any criminal activity by tenants, household members, or guests will result in eviction. Some evictions even occur if the alleged misconduct occurs away from the premises. And they use cause to police reports, or arrests as grounds for enforcement, regardless of whether the events result in a conviction. Just the mere fact that someone has called the police will be a strike against that tenant, and it'll be strike against the landlord by allowing the tenant to remain. It requires landlords to evict entire households, whether or not the triggering activity has occurred, even if the tenant or household member is actually the victim of the criminal activity or simply an innocent third party. There is penalties imposed against a landlord who fails to evict a household once ordered to do so, meaning what? Denial of a rental certificate. Granting few of any procedural protection or defense to enforcement against landlords or residents. In other words, just if it's just the report itself would be grounds, violation of crime-free ordinance, right? Without any finding that there's been criminal activity, you can see what happened. There's no due process protections in that. And here, the core components are lease addendum to allow required landlords to evict tenants who they believe engaged in criminal behavior, right? Under the model, tenant risks eviction if he or she engaged or facilitated any criminal activity. Doesn't even explain what criminal activity is. But notice here, a single violation of any provision of this added addendum shall be deemed a serious violation and material and irreparable noncompliance. It is understood that a single violation shall be good cause for immediate termination of the lease. These have been effective. People that have been subject to this or tenants that have been subject to this, then they basically have to leave the community, have to leave a city and go somewhere else to live. Right? Again, does a resident have to be convicted of an offense to be evicted? No. No. Proof of violation shall not require criminal conviction, but shall be by a preponderance of the evidence, meaning a mere arrest, not resulting in a conviction could be sufficient to evict someone from their home. Right? When a tenant violates a crime-free lease addendum, many of these ordinances either give the landlord the authority to evict for these activities, including those committed by deaths or other members of the household, or mandate the tenant's eviction. It has a lot of interaction and communication between law enforcement, police department, and landlords. None of this is, disclosed to the tenants, right? And there's another one where they label a property a nuisance when it's a site of a certain number of calls to police or alleged nuisance conduct, right? And applies whether or not the resident is a victim of it. The proponents of these nuisance ordinances claim that's necessary to deter crime, but in actuality may have the opposite effect, because what would happen? People will not report it because it can result in eviction. So you run the risk of what? Someone being assault, battery, killed, because they're fearful of making a report to the police department because it can result in eviction. Again, it also violates, for example, nuisance ordinances give rise to violation of the First Amendment right to petition the government, due process guarantees, and federal and state prohibitions against housing discrimination. And that's something. And when it's that communication between law enforcement and the landlord, sometimes the tenants don't even know why they're being evicted, or don't even, they have no opportunity. They don't know what's been said, have no right to challenge it. All right. So what is it? Arrest without convictions do not prove criminal activity. And there, again, there's constitutional issues in it as well. You have a right to make a complaint to a public body, including law enforcement. It's a First Amendment right. You shouldn't be penalized for that. So what do? They punish domestic violence survivors and persons with disabilities who seek help from the police or emergency services, fail to make exceptions for 911 calls, fail to distinguish between victims and perpetrators of crimes, impose penalties on owners leading to evictions of tenants or denial of admission of tenants, even those are actual victims, broadly defined nuisance activities ranging from disorderly conduct to violent crime, negatively impact communities of colors. And I don't have it in here, but there was a case where they showed where the city police department were applying the nuisance ordinance, and they tracked where those occurred. And pretty much they applied the nuisance ordinance to minority communities. And there was one exception, a large apartment complex, which was located in a more non-minority area of the city. But then if they looked at the people who resided in that large apartment complex, and they were majority minority. And those are the ones that they were enforced against. Here's a case study, Briggs case, very recent. Defendants had an ordinance, their old ordinance and new ordinance. They adopted one once it got challenged. it said it authorized defendants to revoke or suspend a landlord's rental license and forcibly remove a tenant from any property where police responded to 3 instances of disorderly behavior at the property within a 4-month behavior. And it broadly defined disorderly behavior. It vested the chief of police with sole discretion to whether the activity constituted disorderly behavior. Under the old order, disorderly behavior could be found in virtually any call to which police responded, including times where a call was made when the tenant was blameless, reasonable in seeking police assistance or facing a true emergency, or whether a call was made by a vindictive, malicious neighbor just to harass someone. So between April and September 2012, defendants enforced the ordinance against plaintiff and plaintiff's landlord by revoking plaintiff's landlord rental license and attempting to remove plaintiff and her infant daughter from the home on grounds that the police were called one too many times to protect her and her daughter from incidents of domestic violence. They assigned 3 strikes to plaintiff and placed her property on a 30-day probationary period. During the period, she was so terrified she would lose her home, she refrained from calling the police during an incident in which she was brutally attacked and almost killed by her former boyfriend. You see the effect. She can't call the police. That'll result in another strike and she will be put out. Right? Defendants continued to take steps to remove plaintiff from the rental property. So what they did is the city acknowledged the deficiency of the old ordinance, repealed it. But after 2 weeks of repealing the old ordinance, they proceeded to enact a nearly identical replacement ordinance without ever forming plaintiff's counsel. And a new ordinance permit them to assess a series of escalating criminal fines against landlords of any property at which within a 4-month period, the police have responded to 3 instances of disorderly behavior, including instances of domestic violence. And that's something just awful, right? It had several effects. The old ordinance, the new ordinance didn't really cure it all that well. Stripped domestic violence victims of police protection, silenced them from reporting acts of violence against them. It exacerbated pre-existing challenges that victims of domestic violence already face. Domestic violence is a serious criminal public health social issue. It's estimated 85% of the victims of domestic violence are women. Oh, sorry, a little bit above. It's estimated that Norristown itself, the city reported to HUD that in 2012, 20% of its homeless population are domestic violence victims. People become homeless to flee domestic violence. And it's so sad if they can't even call the police for protection from domestic violence. Because of the overwhelming numbers of domestic violence victims are women, the old ordinance had an inherent disparate impact on female tenants in Norristown. Amazing. Here's another one, HUD versus City of Hemet, recent conciliation. Hemet spent approximately $1 million in CDBG funds on the enforcement of programs that impose penalties on property owners if 5 or more calls were made to law enforcement or to code enforcement for nuisance at a property. Hemet's policy had no exception for calls from victims of domestic violence or other crime and didn't safeguard any safeguards for individuals with disabilities. The programs required a landlord to enforce a crime-free lease addendum, mandating immediate eviction for a single act of broadly defined criminal activity. Landlords are also subject to annual inspections, fees, and a registration process requiring the property to be kept free from crime, nuisances, and other unwanted behavior. So what they did is the city agreed to repeal rental registration, crime-free rental housing program, including dwelling unit crime-free lease addendum, crime prevention through environmental design, inspection checklists, and so forth. The whole program had to be withdrawn, and the city agreed to create $200,000 remediation fund to improve housing conditions for lower moderate income households, including for proactively addressing potential code violations. And so what they did is the city also had to do in the voluntary compliance agreement, communicate owners of rental properties are only required to submit to the zoning ordinance, crime-free addendum and so forth. And look at this policy here. they published this policy, you may not evict or refuse to renew a lease because a tenant or household member is a victim of domestic violence, dating violence, sexual assault, and so forth. You cannot evict or refuse to renew a lease because a tenant or household member may call for emergency services, including 911. Knowing that arrest on its own is not evidence of a crime. Not all convictions suggest that a person would be a tenant. The best way to assess whether an applicant who has a criminal history would be a good tenant is to conduct an individualized assessment of that person's circumstances, including nature, severity, and recency of each offense and any evidence of rehabilitation. That is a good policy to avoid, fair housing violations, discrimination against women, because women predominantly victims of domestic violence as opposed to men, sex discrimination, right? This is a good policy to use. Examine whatever city you're in, wherever you're located, take a good hard look at the zoning ordinances to make sure that there aren't any of these types of violations. And Illinois Department of Human Rights, I like this, best practices for government leaders. Very good. Got a couple of pages, and here's another one. Carefully assess it. I agree. It should be. It's going to be done. This pendulum swung so far with these crime-free ordinances that if a city municipality doesn't examine it themselves, it may be done by a third party, and there could be a risk of claim that there's been a fair housing violation. Another one, top big area. These are all big areas. Denying accommodations, refusing to provide reasonable accommodations as to land use or zoning policies when such accommodations are necessary to allow persons with disabilities equal opportunity to use and enjoy housing. For example, by denying a request to modify a setback requirement so an accessible sidewalk or ramp can be provided for one or more persons with mobility disabilities. So reasonable accommodation claims often are alleged separate as an alternative claim in a challenge to zoning ordinances. I have a couple cases cited on the right where someone can bring disparate treatment, disparate impact claims, and then also a reasonable accommodation claim. So they kind of go hand in hand, meaning if the ordinance, the zoning ordinance or land use ordinance is not struck down as being facially discriminatory, either in language or an application, or violates disparate impact, having an adverse impact on a protected class, then there can still be the follow-up claim that there should be an exception granted as a reasonable accommodation. And if there's a failure to grant that reasonable accommodation, that can be a standalone fair housing violation. So reasonable accommodations, the Fair Housing Act and legislative history. Here's a section of the Fair Housing Act is an exception in the policies, practices, or services when such accommodation is necessary to afford such person equal opportunity to use and enjoy a dwelling. And the legislative history explained, right? A person using a wheelchair such effectively is just as effectively excluded from the opportunity to live in a particular dwelling by the lack of access into a unit and by two narrow doorways as by a sign posted saying no handicapped people allowed. Strong policy for that. When you look at reasonable accommodation claims, you have to go to look at HUD's implementing regulations. Just 24 CFR 100.204. 204A gives the standard, and B has a couple applications of how that should be applied. The next step is to then look at the policy statements and guidance. The HUD joint statement on land, state and local land use laws and practices and applications for Housing Act has a discussion on reasonable accommodations in terms of local land use and zoning, and then the HUD DOJ joint statement on reasonable accommodations. When it comes to assistance animals, two things should be looked at: HUD's 2020 policy dealing with a person's request to have an animal as a reasonable accommodation under the Fair Housing Act, and then DOJ FAQs on service animals and the ADA. So here's portions from the HUD DOJ joint statement on local land use laws and practices dealing with reasonable accommodations. You can see example here at the top. Locality refuses to waive an ordinance that limits the number of unrelated persons who may live in a single family home, where such a waiver may be necessary for a person with disabilities to have an equal opportunity to use and enjoy the dwelling. Locality violates the act unless it can show that the waiver would impose an undue financial and administrative burden on the local government or fundamentally alter the essential nature of the locality zoning scheme. Can't block a group home or deny a request for reasonable accommodation response to neighbors, stereotypical fears or prejudice about the persons with disabilities or particular type of disabilities. Again, it's not that someone can get up in a public hearing and make a discriminatory statement. It just means that they say council or zoning board shouldn't be acting based on those prejudicial stereotypic views. And on the bottom one, even if a zoning ordinance imposes on group homes the same restrictions that imposes on housing for other groups of unrelated persons, a local government may be required in individual cases and requested to do so to grant a reasonable accommodation to a group home for persons with disabilities. You have to consider whether the requested accommodation is something that can be granted, right? And make an exception. There's, I'm sorry, here's a case study, Smith and Lee versus City of Taylor. Right, Mountain View located in residential community, Taylor zone for single family use. Smith and Lee authority to house 6 unrelated individuals, disabled adults by virtue of Michigan law, which permits adult foster care home for 6 or fewer residents operate in residential zones, including single family neighborhoods. So by the time it purchased Mountain View, Smith and Lee sought to house 12 residents. The director of Taylor's Office of Development Services informed Smith and Lee that the home could not operate with 12 residents unless the city rezoned the property from R1A, single family use, to RM1, multifamily use. They issued a building permit with the express limitation listed on the permit, single family residential use only. There we go. So the district court denied error, concluded that the evidence established Mountain View and other AFCs for elderly disabled and Taylor need an accommodation, that the requested accommodation is reasonable. Elderly disabled citizens have a right to live in Taylor's single family neighborhoods. Second, they need an accommodation. They can't live independently. Adult foster care homes often provide the only means in which adult foster care population can continue to live in residential neighborhoods. And the evidence showed that adult foster care homes in Taylor were insufficient supply because, unlike contract AFC homes, which receive state subsidies, elderly must rely solely on the residents' payments to meet operating costs. So a 6% occupancy limit on for-profit AFCs, right, guarantees a negligible or negative rate of return. In other words, if you restrict it to just 6 persons, there's no way they can feasibly operate. And showing that the need for AFCs in the coming decades outstrips the supply of such homes. And allowing it for housing for 9 elderly disabled residents is reasonable. Michigan already permits 6 or fewer residents in area zone for single family use. Court was not convinced additional 3 residents will fundamentally alter the nature of single family neighborhoods. So you can see none of Mountain View's elderly disabled residents drive. Because they don't drive, traffic and parking problems should not significantly increase. And the court kind of weighing the benefits to elderly disabled against cost. The Taylor conclude that permitting AFC homes for elderly disabled to operate within 9 residents in neighborhood zone for single family use is a reasonable accommodation. I had trouble reading through this to see why it switched from, they wanted 12. And it kind of looked like the courts maybe did a compromise or maybe negotiated a compromise of having 9 residents. A couple of things that come up, procedural issues. Is there necessity, if someone is seeking, for say a group home is seeking a reasonable accommodation, do they have to apply for a variance, or can they make a request for reasonable accommodation and go straight into court? The better approach, probably what courts are going to require, is that they go through the process of applying for a variance, right? Going through the zoning board process and then necessary appealing that. Second, in the Seventh Circuit, in the U.S. versus Palatine case, public input is an important aspect of municipal decision-making. We cannot impose a blanket requirement that cities waive their public notice and hearing requirements in all cases involving the handicap. I've done a couple reasonable accommodation requests when it comes to zoning ordinances. And each time I submitted a variance request, I've gone through the city's process and presented the information before the city. Oxford House versus City of St. Louis. It says, good quote, Congress did not intend the federal courts to act as zoning boards by deciding fact-intensive accommodation issues in the first instance. No, they wanted to go before the zoning board first. Then if that's a denied, then it goes into court, right? There are exceptions. If resort to the zoning variance procedure would be futile, I would still present it even it would be futile, but the Palatine case and another case recognizes that. Additional appeals are not required. Once a group home's request is denied by a planning board, despite opportunity for further appeals, right? And I've seen some where, the appeal process is so detailed, you almost have to appeal it into court, or you don't have to go that far before you bring a reasonable accommodation claim in court once the reasonable accommodation request has been denied by a local zoning board. So they don't require that degree of exhausting, the state process or local process when in terms of making an accommodation request. You can see the Thornton versus City of Allegan case cited their denial of application for a special use permit by city zoning board, though not appealed to state court, is sufficient to fair housing and constitutional claims. Is sufficient to make fair housing constitutional claims right for federal court review. Another would be exception if the zoning variance procedures only require to disabled persons, but not other persons. And on the last one is, even though maybe the variance has to be sought, right? It does not apply to claims of intentional discrimination or disparate impact. Those claims can still be brought. There is no requirement that claims of intentional discrimination or disparate impact be brought before a local zoning board. So one last part, Religious Land Use and Institutionalized Persons Act. This is from the DOJ website. Congress heard testimony zoning authorities are frequently placing excessive or unreasonable burdens on the ability of congregation individuals to exercise their faith. And what happens that they faced subtle and overt discrimination in zoning, particularly those institutions involve minority, newer, smaller, or unfamiliar religious groups and denominations. So religious institutions were treated worse than comparable secular institutions. Some of that is religious discrimination. Some of it also is motivated just because the cities, cash-strapped cities, don't want properties taken off the tax rolls. Some of it's a resistance just on that ground. I have one case I worked on for quite some time. I'm not going into any details with it, but it was actually the largest commercial property in the city. And there was an issue about their tax exempt status and so forth. And there were issues in terms of what it took for them to get a permit to hold religious services at the location. And it was enormous what was required in terms of fire suppression system and so forth. It was borderline. I really thought about bringing a religious land use and institutionalized personal act claim, RLUIPA claim on that basis. Right? So does it apply? Who's bound by it? Yes. Religious Land Use and Institutionalized Persons Act applies to states, subdivisions, counties, municipalities, villages, boards, city councils, planning boards, zoning boards, and zoning appeal boards. Does it exempt religious assemblies and institutions from local zoning laws? No, not at all. It's not a blanket exemption. It just requires, right, that they go through the same process. It can't be, they cannot be treated worse. It's really better just to jump to, I'm going to do it in a second, what the law says on that. On Department of Justice role in enforcing it, yes, they do file lawsuits for declaratory injunctive relief, but not for damages. However, there's no damages awarded to the Department of Justice or the United States, but they can require that there be damages or monetary awards on behalf of the person or institutions that have been injured. It can also require, DOJ can also require zoning code or specific zoning permits be changed to avoid any kind of discriminatory provisions. So here's the law. Why was it enacted? Again, enacted in 2000 due to concerns of land use and zoning. Zoning regulations are being used to burden free exercise rights of religious organizations. I quote the definition of a land use regulation means a zoning or land marking law or application of such a law. Very important, not just the law, but the application of it, that limits or restricts a claimant's use or development of land if the claimant has an ownership, leasehold, easement, servitude, and other property interests. So what is a substantial burden? If the land use regulations impose a substantial burdens on religious exercise, then the municipality will have to show a compelling interest for imposing or applying the land use regulation. So it has to show a substantial burden on religious exercise of that person. Right? Meaning what? That they're unable to really operate as a religious organization or institution because of a land use regulation, right? Once that occurs, municipality, the government must show that the burden on that person, assembly, religious institution, organization is in furtherance of a compelling government interest. And secondly, is the least restrictive means of furthering that compelling government interest. It has a couple important provisions. There's an equal terms provision requiring that houses of worship be treated as favorably as non-religious assemblies. So they cannot be treated in a lesser fashion than non-religious assemblies, institutions, organizations. Prohibits discrimination. Can't discriminate against any assembly or institution on the basis of religion or religious discrimination. And prohibits land use regulation that will have the effect of totally excluding religious assemblies from jurisdiction or assemblies. It says no government shall impose or implement a land use regulation that A, totally excludes religious assemblies from a jurisdiction, or B, unreasonably limits religious assemblies, institutions, or structures within a jurisdiction. So who has the burden of persuasion? Once a plaintiff, religious organization, institution, individuals produce prima facie, on its face evidence support a claim, a violation of the free exercise clause or violation of this statute, the government shall bear the burden of persuasion on any element of the claim, except that the plaintiff has to show that the government practice or action substantially burdens a plaintiff exercise of religion. And key one, I think one is, it doesn't get a lot of attention, effective local or state court adjudication. Typically in these cases, the zoning board of appeals, sometimes even if it gets appealed further into state court, it's upheld the municipality on the application of the zoning ordinance, building restrictions, all of those kinds of things. Typically, the religious organization or institution has lost all the way through the municipal and court process, but that's no effect on this claim because it says under the full faith and credit provision, adjudication of a claim of a violation of this title in a non-federal forum should not be entitled to full faith and credit in a federal court unless the claimant had a full and fair adjudication of that claim in the non-federal forum. In other words, unless the right terminology, religious land use and institutionalized persons act claim was actually alleged in the state process, meaning before city planning, zoning board of appeal, court actually brought up that claim and actually adjudicated it. The fact that there's been rulings at the state level or local level that the building and use requirements are fine and should be imposed, the institution didn't do proper fire suppression system and didn't meet the parking requirements and all of these kinds of things. That gets no weight, no priority at all when it comes to the claim being filed later under religious land use and institutionalized persons act. Nope, get a full fresh start. Why? Because typically they're going to have lost. That's why the case is even being filed. And I know you probably heard news reports of these kinds of claims, right? And it goes back, whether it's a mosque being denied in Sterling Heights or whatever, right? These claims arise very, very frequently. So what are a couple examples? Department of Justice lists a couple. Bethel World Outreach Ministries had outgrown his church, purchased a 119-acre site in the county to build a new 800-seat church. The county subsequently made zoning changes that blocked the development. The church brought suit. Trial court ruled against it. The church reached out to the DOJ. On appeal, the DOJ filed a front of the court brief, argued that the church had outgrown its facility, needed a bigger church, had a reasonable expectation it could build on the property it bought, and that the delay, uncertainty, and expense of looking for different property all created substantial burden on the church's religious exercise. Here's a New Jersey case. Islamic Society of Basking Ridge was meeting in a rented public school and public park, was looking for permanent space, brought a property in a zone permitting places of worship as of right, they met the minimum acreage requirement for places of worship. However, the Islamic Society was denied a permit to build a mosque after 39 public hearings over a 3.5-year period. Islamic Society reached out to the DOJ. After a thorough investigation, DOJ filed suit alleging violation of the Religious Land Use and Institutionalized Persons Act. Ultimately, DOJ and Islamic Society reached a settlement with the township, allowing Islamic Society to build its mosque. Hollywood, Florida, synagogue applied for a permit to operate out of 2 connected houses on a busy street, which had purchased after several hearings, and despite determination by the zoning board that the synagogue met the requirements for a permit, the city commission denied the permit. The DOJ investigated and filed a case alleged the city had given similar permits to other houses of worship and non-religious assemblies, had never before denied any place of worship a special permit to operate in a residential district. The suit also alleged bias against Orthodox Jews by the city. On the eve of trial, the DOJ synagogue and the city reached a settlement allowing this synagogue to operate. So that's what happened. So if it's a religious organization, institution, society, whatever, additional law provides. Again, it could also be, these cases also raise, a claim under the Fair Housing Act because it prohibits religious discrimination. So not only religious discrimination, it also can, constitutional claims, denial of free exercise can be brought as well. But the Religious Land Use and Institutionalized Persons Act is really a more direct law that would apply there. And you can see, again, when I talk about state court adjudications or local adjudications not receiving full faith and credit in Religious Land Use and Institutionalized Persons Act, that's very, very important. I should put a plug in here. I would like that same provision in the Fair Housing Act. I would like the Fair Housing Act to say that a state court adjudication on a eviction case does not receive full faith and credit in a subsequent proceeding under the Fair Housing Act, unless the Fair Housing Act claim was actually litigated in the state district court, eviction court. Meaning what? The Fair Housing Act claim was actually raised, not just included, in an answer or a counter complaint, but actually was adjudicated during the eviction proceeding. But we don't have that kind of protection in fair housing, so it's a real risk to raise anything fair housing related during state court eviction process, which really results in people being evicted when there may have been possible defenses that could be raised just of the concern once the eviction occurs and the state court issue eviction judgment, it can be preclusive as to the fair housing claim. Anyways, all right, let's get back to Steph and Ayesha Curry. So what happened at the end of January 2023? Well, Atherton moves forward with controversial high-density housing project. Well, I asked at the beginning, is zoning and land use boring or controversial? Well, here, right in the article, they say, well, it's controversial. Okay, there we have it. It is controversial. So Atherton officials are moving forward with a quote-unquote controversial plan that would potentially increase housing density in many parts of the town. Steph and Ayesha Curry are among those who oppose the project, citing privacy could be impacted dramatically. The city council approved the plan late Tuesday. This is a tough thing for a community like Atherton to change, after City Manager George Broderick said. It's a sea change. We've never had multifamily zoning. Hats off to the city manager. He knows he needs to do it. For the Curry family, it would mean a multi-million-dollar home on Oakwood Boulevard adjacent to their home would be replaced with perhaps a dozen 3-story townhomes. That's why the Currys wrote the letter asking the town to stand down on approving the project. Part of the Currys' letter reads, and I tried to dig up their letter, I couldn't find it. Safety and privacy for us and our kids continues to be our top priority, and one of the biggest reasons we chose Atherton as a home. There are major concerns in terms of both privacy and safety within 3-story townhomes looming directly behind us. The Currys also asked the town to invest in taller fencing and landscaping to block sight lines into their property if the project is approved. I'm not going to comment on that. This approval of the city housing element clears the way for development, but there is still the public hearing process, which could take up to 3 years. 3 years before a building permit is issued. Incredible. 3 years. Oh my. And it'll be interesting to see what kind of comments are made through the public hearing process. Anyways, thank you all for attending. Our Fair Housing Applies to City, Villages, and Townships and zoning and land use. I hope this was helpful. Can only go into so much detail because it's, it's a complex area with a lot of details, and the cases are so fact specific. But please let us know any other future training topics, anything that you would find interesting or questions that you have. Key resources for zoning and land use. There's a HUD DOJ joint statement. I talked a lot about that today. Nuisance and crime-free ordinances, HUD DOJ, HUD Office of General Counsel has guidance on that, issued in September 2016. There's also a real good article, Harvard Civil Rights, Civil Liberties Review, When Disabilities and Nuisance, How Chronic Nuisance Ordinances Push Residents with Disabilities Out of Their Homes. Of course, there's also race issues as well when it comes to enforcement of nuisance ordinances. Then in terms of accommodations, HUD DOJ joint statement, reasonable accommodations under the Fair Housing Act. And really the above one, the joint statement on zoning and land use by HUD DOJ also touches on reasonable accommodations as well. Then on the Religious Land Use and Institutionalized Persons Act, DOJ issued a statement on the land use provisions of the Religious Land Use and Institutionalized Persons Act with questions and answers. So that's pretty good guidance from the Department of Justice. If you're at the zoning level and that, city council, city attorney, these are all key resources that need to be reviewed just to make sure that no one is running afoul of the Fair Housing Act. Thank you all for participating. I will be staying on to go off recording to answer questions, and we can go even off topic as necessary to answer questions and have good discussions. Like any good discussion, the information and the learning goes both ways. I learn a lot from your comments and questions and things that you share with me. Remember, our Raw Center is always available to answer questions. Our number here, 313-579-FAIR and fairhousingdetroit.org. Thank you so much for attending this morning's webinar on how the fair housing laws, regulations apply to cities, villages, and townships in terms of their zoning and land use laws or ordinances and applications of them. Thank you so much.